We're going to talk today to Herman Edeling, who's going to discuss the introduction of the new Rule 41 capital A into the Uniform Rules of Court. The Uniform Rules of Court govern the procedure in the High Courts in all courts in South Africa. And Uniform Rule of Court Rule 41A is revolutionary in that it introduces mediation as an alternative to the usual litigation stream as an option which parties are now compelled to consider as an alternative. The particular topic that Dr. Edeling is going to talk about is going to address mediation and the advantages of mediation over litigation, specifically from the perspective of the medical practitioner. So we're going to be looking at mediation within the context of clinical negligence, particularly from the medical practitioner's perspective. Dr. Edeling, it's a great privilege and an honor to welcome you. I'm sure you're well known to many of the viewers, but it's always been a source of great fascination to have conversations with you, and I'm really looking forward to our interview today. I'm looking forward to what you're going to say. So welcome.
Thank you very much, Ian, and it's a great pleasure to talk to you.
Now, Dr. Edeling, as you heard, what in particular I would like you to discuss with us is this question of how mediation is likely to affect medical practitioners, particularly in the context of the ongoing medical malpractice crisis in South Africa, and as an alternative to litigation, the advantages which it might enjoy for medical practitioners. Would you maybe like to share some views on that?
Certainly, Ian. A medical practitioner who is faced with an allegation of having committed clinical negligence, it is a very serious problem in that practitioner's life. It is horrible. And whether the allegation is legitimate or illegitimate, it's horrible anyway. So in the first instance, if it is an illegitimate or a frivolous allegation, it's very emotionally taxing. It's very taxing in terms of time and in terms of money to deal with even frivolous allegations. If the allegation has merit, and if the practitioner was negligent, it is that much worse. And from the moment that the letter arrives on your desk until the matter is resolved, there is a very unpleasant conflict. Now, there are major differences between mediation and litigation. And just looking at those differences from the point of view of the doctor or the nurse or the psychologist who has been accused of negligence, I'm just going to talk about it from that perspective.
No, absolutely, Herman. And I think just before you develop that point, just for particularly the medical practitioners, I think just to emphasize that, you know, up to now, the main way in which these disputes are dealt with is in what we would call an adversarial way. In other words, in a kind of conflict-driven way. And now we have this alternative of mediation, which I'm sure will talk to us about a different approach and those differences between the old way and what is set to be a new way to resolve these disputes as an alternative.
Yes.
Thank you, Dr. Edeling. Please carry on.
Certainly. Just interestingly on your last comment, Ian, mediation is new in the medical negligence dispute scenario in South Africa, but it's not new in the world, and it's also not new in Africa. Yes. Mediation is, in terms of what it really is part of a very ancient African tradition of people in dispute coming together with somebody, usually an elder, and talking about it to find a solution. Because really that's what mediation is in its heart. Now, you mentioned the fact that litigation is adversarial. So to put it in simple English terms, once you're caught up in litigation, you have two teams of people fighting with one another. So the whole process of litigation is a fight. And the purpose of the fight at the end of the day is to win. And what most litigants experience, I'm not talking about lawyers, but I'm talking about parties to litigation,
yes,
find that they come off worse off and they are damaged at the end of the fight, even when they've won. And that is in part due to the fact that there's an ongoing conflict that saps your energy, and it saps your willingness to do your work, which is basically based on helping and healing. But now you are the subject of a conflict, and the conflict isn't in your hands. There are other people managing it. So you are more or less a helpless pawn, while other people are fighting for you and other people are fighting against you. So at the end of the day, even if after 3 years or 4 years or 7 years, the court says, okay, no, Dr. X was not negligent, he's off the hook. You've still gone through all of that pain for that whole period of time. Huge financial implications and huge implications on your capacity to do your work, which is to heal people. Now, mediation is not about fighting. Mediation in its heart is about resolving conflict. So that is the fundamental difference, is that mediation actually looks for a solution. It doesn't look for a winner. Now, because mediation looks for a solution, it is possible in many cases to find solutions that satisfy both parties. Because when you turn your focus away from being the winner to resolving the conflict in a sensible and a meaningful way that seems to you to be in line with justice, that is experienced both by the plaintiff and the defendant. And the experience with mediation in the vast majority of cases, is that at the end of the mediation, both parties are satisfied. Sometimes even both parties are enthusiastic and happy. And we have experienced that we have parties hugging one another and experiencing joy because they've resolved the conflict, they're relieved, they're at peace, and they are happy because they think the resolution is good.
So Herman, what you're highlighting there is a feature of mediation as opposed to litigation, which is that, in fact, two features, as I hear you. The first is that the parties retain a lot more control over the process of mediation than they do in litigation. And you talk about litigation, you feel like you're almost a pawn when you're one of the parties. In mediation, that is a very different approach, where the parties are at the heart of the dispute resolution process, and in fact dictate actually what happens ultimately. Exactly. And the other difference is the difference between litigation being a sort of a contact sport, a collision between two teams, and there's going to be one winner and one loser according to preset rules, whereas mediation looks to see ultimately if there can be a win-win solution, and you rather almost work together to resolve this conflict and come up with a creative solution, so there's more capacity to find solutions. And maybe, Herman, let's talk about that aspect of mediation, if you wanted, on how it's dynamic and you can be constructive and creative in finding solutions.
Yes. Now, Ian, as a lawyer who's very experienced in medical malpractice litigation, you will know that once a doctor has received the particulars of claim and the summons, he's not allowed to talk to the other side.
Yes.
Now, the other side used to be his patient. Now it's his enemy. And in many cases, the biggest need of the patient, who has now become a claimant, is to understand what happened.
Yes.
And many medical negligence cases you will find in the particulars of claim, or you will find in the expert reports, that people complain bitterly. When this thing went wrong, the doctor wouldn't talk to me.
Yes, exactly.
And that is a complaint that is repeatedly mentioned by the patient and also very much by the family. So yes, my father's in hospital, suddenly he's not doing well. Hell, doctor, I'm having a fright. What's going on here? No, we're not allowed to talk to you. Or I'm not available. I don't answer my telephone. The nurse isn't allowed to give my cell phone number to you. When you phone my rooms, then the secretary says I'm busy or I'm operating or something. And people complain a lot about that, Ian. They wanted to talk to the doctor, but they couldn't.
Now, and then what happens is when that channel of communication is broken down, that then fuels that cycle of conflict, because now there's misunderstanding, and each side, it's like an arms race now between the two sides.
Yes. And in many cases, people have said, well, the doctor caused me a lot of harm, but he was so understanding and he spoke to us so nicely and explained it all so well, and he seemed really to care that we couldn't possibly sue him because we feel sorry for him.
That's right, yeah.
You see, so clinical negligence conflicts are not simple right or wrong issues about whether you were negligent or were not negligent, and simple legal issues about whether this thing factually caused the outcome and whether there's legal causation and what the quantum is. Those are fairly concrete concepts that litigation and courts deal with. But there's a lot of human being in conflicts. There's human emotion, there's human understanding, and there are human interests. And a major interest in all cases of patients and their families is to understand.
Yes, very much so.
I can't tell you how many times, I think it's 100% of times, that I interview people years later when I get briefed to write a report on a negligence matter. And I spend time with the people and I read the records and I read the clinical reports and I listen to them. And then I can see, but there's something important here they don't understand. In the consultation, I explain to them what the doctor wrote there means this and this and this. Oh, gee, thanks, doctor. That's the first time anybody's explained that to us. This can be 3 or 4 years after the event.
Now, Herman, that is exactly my experience as an advocate as well. Yes. Particularly when I act for plaintiffs, you find that they will come to you and often the plaintiffs themselves, I must tell you, are very receptive to the idea of mediation. And one of the main reasons for it is that they say they want to understand and they actually want to open, they very often are very willing to open a constructive, properly supervised dialogue with the practitioner. And the other thing that I must say in my experience, which is related to this, comes up, is often you will hear patients say something to you along the lines of, I just want to make sure it doesn't happen again. So there's that type of sentiment comes through as well, which again, mediation can address that process if I understand it. And maybe just talk a little bit on that aspect.
Yes, many people have that interest. It's like a public benefit interest.
Correct.
They've suffered. There's nothing that can bring their dead relative back to life, but they don't want other people to suffer the same problem. And the litigation has got no mechanism for dealing with that.
Yes.
Because the litigation ends saying who must pay who how much money.
Correct.
Whereas in mediation, and we have had this experience over and over, because we mediate between the plaintiffs and the representatives of the hospital, usually a state hospital, that our experience has been, then it's very comforting and meaningful to them when the representative of the MEC says, we've taken note of this problem, we have disciplined the person who was guilty, and these are the measures we have already introduced to make sure that it doesn't happen again. Exactly. People find it very important. Now, from the point of view of the doctor who has been accused of negligence,
yes,
mediation is a safe environment to have a positive and constructive discussion, particularly because it is entirely confidential and it is without prejudice. So the doctor can explain truthfully what happened, and whatever he says to the people in the mediation cannot be used against him if the matter ever goes to court. He can even say, I agree I was negligent. And if they then don't settle the matter on quantum or whatever reason, and the matter does go to court, the plaintiff and the plaintiff's lawyer cannot argue the doctor conceded negligence in mediation, because what is said in mediation is legally privileged. So
that's 100% correct. And Herman, I just want to add something there that you know what you're talking about is a very, very important feature of mediation, which is the confidentiality of the process, and
Yes.
you can say the integrity of the process. Now, that is obviously on a mediation which is properly conducted, and that is what we're talking about here. I want to say that there are other videos that will be posted and other information explaining these concepts. For instance, of what does without prejudice mean, what does privilege mean, confidentiality, and also importantly, going through what the proper structure of a professionally acceptable type of mediation is. And there will also there's also information on who provides those types of services. But your point is very well taken, Herman. I think it's a central feature. Just in closing, because we've got a minute or two left, I think maybe if you can summarize your key thoughts, Herman, on mediation from a medical practitioner's perspective, and some words that you might say to fellow medical practitioners.
Okay, Ian, I'm going to start with an important concept that we haven't mentioned. Two important concepts. The first, it can come to resolution much more speedily than litigation.
Right.
Mediation can resolve it much quicker. And that is in everybody's interest, because for the doctor, when it's over, then it's over.
Yes.
The second thing is it's much cheaper. So even if the doctor's insurance company is paying, indirectly the doctor and all his colleagues in the country are paying through their insurance premiums. But legal costs of litigation are very much higher than the legal costs of mediation. So it's quicker and it's cheaper. So for those reasons, emotionally, much better. But also, Ian, because of the confidentiality, it doesn't get into the press. Whenever the doctor is in court on negligence charges, that's very exciting news to be put in the press. The doctor's name is damaged by that. That doesn't happen with mediation. So for the doctor, it is much quicker, much cheaper, much safer. And also, all doctors are human beings whose primary purpose in life is to help and heal people. Mediation gives the doctor the opportunity to explain to his patient what went wrong. And when the doctor explains it in an honest and simple manner that the patient can understand, there's a huge forgiveness that arises. And this is not just what we speculate, this is what we experience. And it makes the doctor feel much better, and it makes the patient feel much better. Sometimes doctors also then come to the point where they want to apologize. And an apology is also a very powerful mechanism. But even without apology, Ian, simply an honest explanation has got huge power of restoring the relationship, restoring the trust and the respect. So for those reasons, Ian, and there are more things we can talk about, I think it's a no-brainer. A doctor who is accused of negligence should ask his lawyers and his insurance company to deal with the matter through mediation.
Well, thank you very much, Herman. And you're right. This topic is so rich, and there's so many points that we can develop. And I'm sure that in the days and weeks to come, we will have many conversations on those points, and we will develop them. Also, as this concept of mediation now starts getting formal recognition as a speciality within its own right, within the legal process and the legal structure, obviously there will be development around there, and we can keep up to date with that as well. Yes. Herman, I just want to just before we close, just to pick up on one point, what I've always said is, the last thing that a medical practitioner needs to see is driving down the road, newspaper headlines, doctor found not guilty of clinical negligence. Yeah. You need to keep that out of the papers, even if you're not guilty. By insinuation, it affects your reputation. And it's, as you rightly say, we see firsthand the kind of stress and the pressure that it brings to a medical practitioner when you go through the litigation channel. And I completely agree. Mediation in the right circumstances with the right parties absolutely can have a very, very positive effect. Herman, I'd like to thank you for your time and for the fascinating chat. I hope that people watching this have found it informative. I certainly have, as ever, when I speak to you. And I hope that this is the beginning of the South African legal system looking at the way that it deals with disputes, across our culture and across our country, in a different way, in the sense that there's an alternative that slots in its rightful place, which is mediation. That's not to say that litigation will not sometimes be appropriate. Of course, it always will. But particularly in clinical negligence matters, it seems to me that there's a very important role for mediation to play. Any closing thoughts, Herman, from your side?
Ian, first of all, I want to thank you for your initiative in developing your medical ethics and law website, because I think that will make a tremendous adjunct to the work that the South African Medical Legal Association is doing, and for your collaboration with us in terms of improving the circumstances and the playing field of medical legal dispute resolution. So congratulations and thank you. And it's a great pleasure to talk to you about this.
Thank you, Herman. And can I, in turn, just extend my appreciation and support for the South African Medical Legal Association and for yourself. And I look forward to us working on what I know is a central core ethical concept, which is the promotion and improvement of professional services within the clinical negligence sphere. Well, thank you very much, Herman. Have a good day. Bye-bye.
Bye-bye.